In a 2007 case, Massachusetts versus Environmental Protection Agency, the United States Supreme Court held that Title II of the Clean Air Act authorized the Environmental Protection Agency, or EPA, to regulate greenhouse gas emissions from new vehicles. That holding prompted the agency to adopt certain interpretations of other titles in the Act. In Utility Air Regulatory Group versus Environmental Protection Agency, we explore whether those agency interpretations were entitled to judicial deference. Under Titles I and V of the Clean Air Act, permits were required to construct, modify, or operate stationary sources, such as factories and power plants, that emitted either 100 or 250 tons of certain air pollutants per year. Sources subject to the permit requirements had to abide by emission limits based on the best available control technology, or BACT, for each pollutant subject to regulation under the Act. After the decision in Massachusetts, the EPA determined that if it regulated greenhouse gases as an air pollutant under Title II, greenhouse gases must also be considered an air pollutant, triggering permit requirements. That interpretation would have subjected many small stationary sources to permit requirements, because office buildings, retail stores, and other similar facilities often emitted more than 250 tons of greenhouse gases per year. To combat that outcome, which Congress couldn't have intended, the EPA adopted a heightened triggering point of 100,000 tons per year for greenhouse gas emissions. But major stationary sources already subject to permitting were required to comply with BACT standards for greenhouse gases. Various parties filed petitions for review of the EPA's interpretations in the D.C. Circuit. The D.C. Circuit upheld the interpretations, and the United States Supreme Court granted cert.